Hello again, everybody. This is attorney Mark Brunner, and thank you again so much for joining me today here on Talking Texas Law. Well, today we're going to take a look at a kind of a strange offense. It's a little bit of a mismatch of a crime that maybe the Texas legislature sort of did a catch-all and put a couple of different things in together under one section. And we're talking about the offense of deadly conduct. It's coming at you from section 22.05 of the Texas Penal Code. And again, a little bit of a strange catch-all offense. It sounds really scary, deadly conduct, but let's unpack what the legislature meant and some of the penalties therein. So the offense in Texas of deadly conduct can be committed two separate ways. The first way is really very vague and contains a lot of concepts that we'll talk about here. So the first way that you can commit the offense in Texas of deadly conduct is by what's called recklessly engaging in conduct that places another individual in imminent danger of what's called serious bodily injury. So again, recklessly engaging in conduct that places another person in imminent danger of serious bodily injury. To commit that offense, if you commit that offense, that's a Class A misdemeanor. It has a range of punishment of anywhere between up to a year in jail, up to a $4,000 fine. That jail time could be probated for up to 2 years. So a misdemeanor level offense. Let's look again at that. So there's a lot of concepts buried in that one sentence. Okay, someone has to recklessly engage in that conduct. So there's different mental states under Texas law. The lowest is what's called criminal negligence. And it goes recklessly, knowingly, and then intentionally. I meant to do that to that person. So reckless is one of the lower standards. So if the state can only prove that someone negligently did the act, well, then that's not reckless. They're not meeting the offense, and that person would be found not guilty. So they have to show recklessness. Also, it has to be that the conduct places another in imminent danger of serious bodily injury. So imminence, that's another concept that gets unpacked here. Imminent means immediate. Right now, it's about to happen, not sometime in the future, not contingent upon A, then B, then C, then maybe D. Here comes the harm. No, it's got to be an imminent harm. So if the state can only prove some sort of theoretical possible harm in the future, or it has to be a scenario of certain things falling into place before that harm could come true, that's not really deadly conduct. It may be something else. And then the danger has to be to the victim. That imminent danger has to be of serious bodily injury. Now, that's another concept that Texas defines separately. Serious bodily injury is a concept. It's not just what's called bodily injury, which is really just any kind of pain. Serious bodily injury means something that, injury that runs the risk of causing death or disfigurement, permanent impairment, things just scarring or certain broken bones. So we're not talking about bumps and bruises here. So again, a lot of different things that perhaps the state would have to prove in this situation. They have to prove recklessness, they have to prove imminence, and they have to prove serious bodily injury, not just the risk of some minor harm. It's got to be a serious, immediate harm done recklessly, or at least the threat thereof. So a lot to unpack for simply a Class A misdemeanor. You know, some states may call this something along the lines of reckless endangerment or something else like that, but here in Texas it falls under that general statute of deadly conduct. So I told you there was another way, a second way for this offense to occur, and that is a lot more specific, and it really has nothing to do with the first offense. It's much more dialed in, and let's talk about that second way that Texas can show deadly conduct. And this is if someone would have engaged in deadly conduct if they knowingly discharge a firearm, meaning shoot a firearm, at or in the direction of either an individual or a habitation, building, or vehicle, and they are reckless about whether that habitation, building, or vehicle is occupied or not. Okay, so again, sort of two different ways. Either you're shooting a gun, discharging a firearm at somebody, or at a house, at a building, at a vehicle, and you're reckless about whether or not that structure or that vehicle is occupied. Again, you see that doesn't really match up with the first way of committing deadly conduct, so the state kind of just crammed it all in there together as a catch-all, but there it is. So this second way of committing deadly conduct, about discharging the firearm, this is a third-degree felony if it's been proven by the state. And so this carries a range of punishment much more serious, anywhere between 2 to 10 years in prison, up to a $10,000 fine, and the prison time could be probated for up to 10 years. So we're not talking about county jail time. We're talking about a third-degree felony. So again, one offense, two different ways to prove it. One's a Class A misdemeanor. One can be a third-degree felony. Many different ways, again, to commit the offense. So again, that second way, again, you've got some mental states that are at play here. The state of Texas would have to prove that the person knowingly discharged that firearm. So if they're only able to prove the person negligently or recklessly discharged the firearm at or in the direction of somebody, or a person, structure, vehicle, what have you, they wouldn't be able to prove the offense. They have to show that higher standard of knowingly. So again, a lot of different mental states to try to unpack under that second way to show deadly conduct. Knowingly discharge the firearm. You are reckless about whether that vehicle or structure is occupied. So again, different sort of mental states that evidence has to address. Furthermore, on that second way of proving deadly conduct, the defense that I didn't know the gun was loaded specifically is ruled out as a defense. Whether or not the actor believed the firearm to be loaded at the time of discharge really doesn't matter. The statute specifically bars that as a legal defense if it's pointed at another person. So that defense is not really available. So there you have sort of the hybrid mishmash catch-all offense of deadly conduct. It could be a misdemeanor, it could be a felony, depending on what we're talking about. Just general reckless conduct that places another in imminent risk of serious bodily injury or death. Or are we talking about a knowing discharge of a firearm at a person, building, or vehicle? Two different ways to commit the offense, but there we have it. That's, in a nutshell, deadly conduct under Section 22.05 of the Texas Penal Code. As always, this video is being offered for educational and informational purposes only. It's not to be construed as giving specific legal advice, and this is not a legal consultation. And unless you are already a contracted client of mine, I'm not your lawyer. This has been Attorney Mark Brunner, and thank you so much for joining me today on Talking Texas Law. I'll see y'all next time. Thank you.